Good day, Crime Talk aficionados. Yes, we basically took last week off because I was in trial, but guess what? We're back this week. So first on the docket, newly released documents shed, a little more light on that creepy Bryan Kohberger's actions. The bond bid for a besieged ex-sheriff, a $50,000 gamble, probably best reserved for his legal lifeline, i.e. his attorneys. A heroic mom turns a burglar blues into a bullet point victory in a suburban standoff. What are kids thinking these days? A tragic tale of teenage treachery in South Carolina. Push to the brink, the ironic end of a benevolent boss who was buried by his own excavator. We have this day in legal history, legal quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember, you can check us out anytime on any of your favorite podcasting apps. Before we get started, let me remind you to go to crimetalksearch.com, sign up for a background subscription service today. When you do, you'll be able to do as many background searches as you desire. And guess what? The report is literally prepared and emailed to you while you wait, and you're going to find out all types of information about somebody's email presence, their addresses that they use. You're going to find out phone numbers, social media presence. Do they have a criminal history? Are they married? Are they divorced? Are they on one of those sex offender registries? Yes, everything that they maybe won't tell you. And you maybe say, why, Scott, do I want to check out anybody? There's nobody to check out in my life. I'm sure you all trust your significant others. But, maybe if you got that weird feeling that maybe something isn't right, go check him out. See why he has 5 or 6 email addresses. Is that what he uses to sign up for his dating apps? You may want to try to find that out. Go to crimetalksearch.com, find out today. All right. As I mentioned earlier, we were not here last week, except for, I think, one day, Thursday, after I had just gotten my butt kicked in a homicide trial. Now, we proceeded to immediate sentencing because the only sentence was life without the possibility of parole. And I think I told everybody it stung a little bit. I haven't had a loss on a first-degree murder case in a long time. Because either one, we've wanted a trial, or two, we were able to resolve it. And although our attempts to resolve it this particular time didn't work out, neither did the trial, nor the lesser included offenses that were offered for the jury. And it was funny because I even thought that the prosecutors had talked the jury out of first-degree murder in their closing statements. And no, the jury was quite convinced that it was first-degree murder. But little pro point that I gave last week, if you're going to shoot somebody, don't do it. First of all, don't do it. All right. Don't do it unless you're absolutely certain it's self-defense, right? But one, don't do it, particularly if you know it's on camera. Multiple angles. Don't run up to somebody and shoot them in the back. Pro point. It's just going to make the job a lot easier for your attorney. Don't do that. All right. So, I know I wish I could win every trial that I go to. It doesn't happen. We've pulled out a couple of good ones lately, but this one was just not meant to be. But welcome to the life of a criminal defense attorney, right? Everybody thinks you're supposed to lose because, the prosecution has much better facts. And all prosecutors have to do is get up and say, and what happened next? And then what happened? And then what did you do? Pretty basic. Defense attorneys have a little more difficult in my humble opinion, but they got the best of us this last week. It was a fair fight, good jury. Wouldn't second guess the jury. I can completely see how they came to their conclusion, but we'll leave it at that. All right, let's go ahead and open the record for Monday, August 18th, 2025. So some newly released documents shed a little light on Bryan Kohberger's creepy actions. That's right. So some recent disclosures from the Idaho State Police and court records have provided some fresh insights into the 2022 murders of the 4 University of Idaho students, obviously perpetrated by Bryan Kohberger. Now, these materials, including unsealed interviews and investigative reports, highlight details from a surviving roommate's account, warnings about Kohberger's behavior during his graduate studies, and evidence of potential stalking incidents involving one victim. Now, Kohberger, who obviously pled guilty to the crimes and is now serving 4 consecutive life sentences without the possibility of parole, continues obviously to draw a little more scrutiny amid these revelations. So what do we know? Dylan Mortensen, one of the two roommates who survived the November 13th stabbings at the off-campus residence there in Moscow, Idaho, provided key details in her police interviews. Now, according to these documents, Mortensen awoke in the early morning hours to sounds of distress, and she reported hearing a male voice unfamiliar to her addressing victim Kaylee Gonsalves by name, stating something to the effect of offering her help and reassurances. Now, Mortensen initially believed the crying she heard came from Gonsalves, but later considered it might have been from another victim, Xana Kernodle, possibly attempting to escape. Mortensen also described encountering a masked intruder in the kitchen, approximately 5 feet 10 inches tall, dressed in black. Now, the individual assured her he was there to assist before exiting through a sliding door, and although unharmed, Mortensen expressed certainty about hearing Gonsalves' name mentioned. However, she admitted difficulty in visually identifying Kohberger from photographs post-arrest, noting that the media coverage had helped her connect him to the events. At Kohberger's July 2025 sentencing hearing, Mortensen delivered an emotional statement describing him as devoid of empathy and remorse. And the victims, obviously, Kaylee Gonsalves, Madison Mogan, Ethan Chapin, and Xana Kernodle, were attacked in their beds, and the autopsy details indicate Gonsalves suffered over 20 stab wounds and blunt force injuries, underscoring the brutality of the assault. We've also learned that, well, there was a lot of red flags. So prior to the murders, Kohberger was enrolled as a PhD candidate in criminology there at the Washington State University in Pullman, Washington. And he was also working as a teaching assistant. Well, the records reveal multiple complaints regarding his conduct, including inappropriate interactions with female students and faculty. One professor reportedly escorted a student to her vehicle due to concerns over Kohberger's demeanor. A particularly alarming note that an unnamed faculty member shared months before the killings predicted that awarding Kohberger a doctorate could enable future predatory behavior. The professor experienced in working with offenders warned colleagues that Kohberger might later be accused of harassing, stalking, or abusing students if he became an academic. Peers described him as condescending, especially towards women, studying topics like sexual burglary, and speculated he exhibited traits associated with involuntary celibacy or potential for sexual violence. Now, Kohberger's academic interests focused on psychological aspects of criminal acts, including offenders' emotion during crimes and strategies to evade detection. He briefly discussed the murders with classmates, labeling them as tragic and suggesting they might have been an isolated incident. Well, we also know from the documents, they outline reports from Kaylee Gonsalves about feeling pursued in the weeks leading up to her death. She described incidents such as spotting a man observing her from behind a dumpster near her home and being followed to a car in a grocery store parking lot where the individual attempted to access her vehicle. Additionally, her parked car was broken into with items rearranged, a suitcase left in the street, and undergarments stolen. Similar experiences were noted at the Washington State University, where a graduate student reported a burglary involving the theft of intimate items like perfume and underwear. These parallels have fueled speculation about targeted motives, especially given that Kohberger addressed Gonsalves by name during the attack, implying prior knowledge of her identity and location. We've also learned that digital forensic from Kohberger's phone revealed only 18 saved contacts, many labeled unusually weird, such as girl I ran with, or entries noting their physical attributes like hair. This sparse list included family members and a few others, contrasting with most people's typical social network. Now, following the guilty plea, which spared Kohberger the death penalty, Kohberger was transferred to a prison facility. Recently, there's been footage purportedly showing him in his cell, pacing and examining his discolored hands, apparently possibly from excessive washing or maybe the re-fingerprinting there at the Department of Corrections. Anyway, the Department of Corrections officials have verified the video's authenticity, but they said, hey, beware, there could be potential AI alterations in the future based upon that video. And for those who don't recall, that's right, Bryan Kohberger has waived his right to an appeal or the request for any sentence reduction as part of his plea agreement. So guess what? That will never be an issue in this case. I think we all knew and realized that the defense was trying to set expectations early on by saying, hey, our client's a really nice guy, but he's a little awkward, a little weird. And so they were trying to set the stage. They were trying to see how that was going to, come out in the public and if people were going to comment on it. And clearly they did, because they knew if they had gone to trial, this stuff was coming. All right. And everybody knew early on, okay, he's a little weird, a little awkward, but then it came out, he's just weird and creepy. All right. And it's funny that the people, and this is the problem with kind of, you can't be honest with people when you got these professionals saying, hey, this guy could be a predator based upon what I have seen and observed him interacting with students. And the way he conducted himself around women, clearly he did not have any respect for women whatsoever. And it's all just coming out. Everything that we envisioned, we all speculated about, is true. There was even one of the reports I was reading about Kohberger where he went to the grocery store and was commenting with the lady that worked at the grocery store, like knew her by name and things like that, but she had a husband. But Kohberger was just getting weird and creepy, and other people's stuff disappearing around their house. I'm telling you, the Moscow, Idaho incident is not the only one. Now, I'm not saying he killed other people, but this dude was creeping around in the dark because he's a freak, ladies and gentlemen. And, the problem with kind of today's world is that nobody calls out the freak anymore. And what do? You have to wait and say, well, we knew we saw it coming after he does something, because everybody's afraid of being sued. Everybody's afraid of being labeled something. You're being insensitive. He's just awkward. Or you can say he's a freak and I wouldn't want him hanging around my daughter. And he's a predator because that professor studied predators and said this guy is a classic predator. And what do we talk about? Sometimes people, they want to be in those positions where they can get around people they want to be with. I don't know. I just think the more and more stuff comes out on Kohberger, people need to be enlightened, have their eyes opened up that this guy is a freak. He is dangerous. He killed 4 people, probably could have done more. And if he had gotten away with this, there definitely would have been more. Next, the bond bid for the ex-sheriff. So as the calendar edges toward the 1-year mark since a Kentucky district judge met a tragic end in his own courthouse chambers, the debate over pretrial freedom for the accused former sheriff lingers like an unresolved verdict. Now, Sean Mickey Steins, one of the lawmen there of Letcher County, finds himself ensnared in a capital murder charge, with his defense team now angling for a modest $50,000 bond, cash or property, to secure his release from awaiting trial. One might quip that facing the possibility of a permanent change of address to state accommodations, Steins could be wiser to hoard every penny for the attorney's fees that promise to amount higher than the Appalachian Hills. Now, in a courtroom exchange on August 15th, the defense attorney, Carrie Bartley, painted Steins as the epitome of reliability, deeply rooted in his community, buoyed by family ties, including a wife and daughter, and posing negligible risk of flight or harm, the lowest possible level for risk, she asserted, emphasizing that no evidence suggests otherwise. Yet the special prosecutor, Jackie Steele, countered with constitutional precision, invoking Kentucky's charter, which bars bail for capital offenses where proof is evident and presumption is strong, rendering community goodwill irrelevant to the gravity of the accusations itself. Now, Steins has remained incarcerated in an eastern Kentucky facility since surrendering without resistance following the September 19th, 2024 shooting of Judge Mullins there in Whitesburg, Kentucky. Now, pleading not guilty to the murder of a public official, a charge that could invite the death penalty, though prosecutors have yet to declare their intent, Steins resigned his sheriff post mere days after the incident, and the motive remains shrouded in mystery, despite revelations that the two men, longtime acquaintances, had lunched together hours before, with Mullins suggesting a private meeting with whose purpose eludes clarity. Now, the presiding judge, as a special appointee, deferred a decision on the bond during the hearing, granting both sides until September 2 to submit additional arguments on this and other pretrial issues, including motions to unseal Stein's psychological evaluation and the motion to dismiss the indictment. The judge pledged to accelerate his rulings, potentially paving the way for a trial, but it will be scheduled soon after. Now, a prior hearing unveiled some chilling silent footage of the event, a figure identified as Stein's drawing a firearm, firing at the seated judge, then advancing to discharge more rounds as Mullen sought cover behind the desk. And in a community that's interwoven as Whitesburg, nestled some 100 miles southeast of Lexington near the Virginia border, the shockwaves in the small community continue to reverberate. Now, while the attorney's plea underscores Stein's ties to hearth and home, the prosecutor's stance serves as a stark reminder. In matters of life and death, constitutional safeguards trump sentiment. For Stein's, that $50,000 might indeed prove a fleeting temptation. Better perhaps to earmark it for the defense arsenal, lest the scale of justice tip toward an extended involuntary sabbatical. Mr. Stein's, okay, let me give it a pro point. Just did this trial. Don't walk towards somebody who's unarmed. Shoot him in the back. I know you didn't shoot the judge in the back, but you might as well have. It looks bad on video. You're not going anywhere. And save the $50,000 for your defense attorneys, or save it for your commissary fund when you get to prison. Don't be wasting time and money on things that are not going to happen. You're not going to go anywhere. When there's proof evident presumption, great. You're not entitled to a bond on a capital offense. That's just the way it is. I know everybody wants to get out on bond, but once everybody gets out on bond, they're unrealistic about going back on bond, going back into custody. It's very frustrating. Sometimes you just have to suck it up and do the time. Next, a heroic mom. All right. In a display of maternal instinct that would make even the fiercest lioness nod in approval, an Illinois mother swiftly safeguarded her infant son from an uninvited nighttime visitor and decisively ended the threat with her legally owned firearm. Now, this tale is from Joliet's tranquil suburbs, serves as a reminder that while burglars may pick locks, they seldom anticipate picking a fight with a prepared parent. Now, the incident unfolded late Friday evening at about 10:30 p.m. in the Verdant neighborhood of Lakewood Prairie, which is apparently roughly 7 miles east of downtown Joliet, there in Illinois. Now, upon detecting the sounds of the intrusion, the quick-witted mother, whose identity remains undisclosed, ushered her baby into a second-floor closet for concealment. Moments later, the intruder, clad in gloves and armed with a screwdriver, invaded the bedroom. Undeterred, the mother discharged her handgun, striking the assailant fatally in the head. Nice shot. Police pronounced the dead guy deceased at the scene, with identification pending. Responding officers discovered the mother and child unharmed in a nearby room. She informed investigators that the intruder was unknown to her. Well, the Joliet Police Department continues its active inquiry, noting the mother's full cooperation. So the suburb, nestled about 40 miles southwest of Chicago, contrasts its recent growth from 77,000 residents in 1990 to nearly 150,000 in 2023, with occasional shadows, including a tragic family massacre back in January of 2024 that claimed 7 lives before the perpetrator's self-inflicted demise in Texas. Well, public sentiment has rallied around the mother, with social media abuzz on the Joliet Police Department's platform. Admirers dubbed her Mother of the Year, lauding her composure under duress and suggesting civic honors. One commentator highlighted the value of firearm proficiency for women, implying that without it, the outcome might have veered tragically. Indeed, in protecting her offspring as nature and nurture dictates, this heroine not only neutralized the peril, but also underscored the timeless role of guardianship. Now, let me make a prediction here, ladies and gentlemen. Bad guy, career criminal. Mark my words. We'll follow up tomorrow and see how that turned out. Anyway, people are talking about, obviously, the mother's valor, but hey, you too can take some tips to protect yourself. A security setup is obviously quite good. Security cameras are rather inexpensive these days, and a lot of them are wireless. Back in the day, they used to run by cables, expensive. You had to pay people to monitor it. Now you go down to the old Home Depot, and guess what? You pay a couple $100, your whole system is up within minutes. Light, all right? Visible cameras and motion-activated lights eliminate hiding spots. Transform your property into an unappealing target. Light it up like a Christmas tree. The 4th of July. Burglars don't go where there is light because that means people can see them, right? You turn on the spotlight, little cockroaches run. They don't like it. Secure entry points. Reinforce your doors, windows, and garages with deadbolts and barriers. Avoid leaving tools accessible as they could aid the intruder. How about talk to your neighbors? Trade a little minor privacy for neighborhood watches or shared alerts, creating a collective shield. Pets, always a good sign, right? They bark. Good surveillance system. And of course, get a gun. If you feel competent, and if you do get a gun, go get the training that you need. But like this mother, boom, single shot to the head, bam, bad guy dead, small child safe, mom is safe, not gonna be charged. She was defending her family in her castle, ladies and gentlemen, defending her castle. Next on the docket, what are kids thinking these days? The follies of youth. What on earth are these kids plotting in their group chats nowadays? In a plot twist straight out of a bad teen thriller, 9 South Carolina teenagers have been rounded up for allegedly orchestrating the murder of a 16-year-old by the name of Trey Dean Wright. And get this, even his own girlfriend was apparently in on the deadly double cross. Now, one has to wonder if this what passes for relationship drama these days with the young kids. Anyway, what we know is Wright's body was discovered back on June 24th, riddled with gunshot wounds on a lonely stretch of First Neck Road in Florence County, South Carolina, which is about 45 miles west of Myrtle Beach, for those mapping this out. Anyway, police point the finger at 19-year-old Devin Scott Raper from Conway, South Carolina, who allegedly pulled the trigger during the squabble over, you guessed it, a girl. He was nabbed the very next day, but oh no, this wasn't a solo act, ladies and gentlemen. In the ensuing weeks, 8 more teens joined the suspect lineup, charged with luring Wright to his doom. And because why not add insult to fatal injury? Filming the whole gruesome affair. Among them, Wright's 17-year-old girlfriend, Jean Kistemacher, accused of being an accessory before the fact. Apparently, she knowingly escorted the armed Raper to meet her boyfriend, sparking the fatal confrontation. What happened to good old-fashioned breaks up? Text messages, I guess. Rounding out the cast of this ill-conceived scheme are 18-year-old Corinne Belviso and Hunter Kendall, plus 17-year-old Sydney Kearns, all slapped with charges for their role in the setup. 4 other minors are involved, but their details remain under wraps, probably for the best, lest we all collectively sigh over the state of adolescent decision-making. As Major Michael Nunn of the Florence County Sheriff's Office explained, these accomplices were fully aware they'd be delivering an armed hothead to a scene, complete with threats and firearms waved in Wright's face. Now, the sheriff summed it up with a rhetorical zinger. They had issues with each other, and it was over a female. The sad thing is, you got a 16-year-old that lost his life. You've got a 19-year-old who is going to be in jail the rest of his life over what? And yes, Mr. Raper faces murder charges and possession of a weapon during a violent crime. He's being held without bond in the Kendall County Jail. Belviso and Kearns each posted a $20,000 bond and are out pending trial. Meanwhile, the rest of us are left scratching our heads in an age of endless TikToks and the Snapchat streaks. Is this really how today's teens resolve a little love triangle? Kids these days, seriously, what are they thinking? All right, You ever heard of the quote, no good deed goes unpunished? Well, let me give you an example. In a twist of fate that could only be scripted by a darkly comedic playwright, a young Colorado man has confessed to dispatching his generous employer in a fit of impatience, opting for a solo act in what was meant to be a duo's heist. Please meet Luke Shelton. That's right. At the tender age of 21, he has sealed his future behind bars as of August 13th of this year. How did he do it? By pleading guilty to second-degree murder and meddling with a corpse. The result? A hefty 56-year sentence, 48 for the murder, and 8 for the post-mortem mishandling. Now, this little saga unfolded back in January of 2024 when Shelton, employed on the property of 58-year-old John David Vieira, decided that gratitude was overrated. Court records reveal that Shelton had been hatching a scheme to eliminate Vieira, conceal the evidence, and divvy up the spoils, equipment, titles, and assets with a fellow coworker. Alas, coordination proved too taxing, so Shelton improvised alone. The catalyst? A heated spat over a truck that particular morning, which Shelton later described to authorities as Vieira having pushed me too far. In a move blending audacity with inefficiency, he shot Vieira, loaded the wounded man into an excavator, and interned him in the soil, cheekily directing police to the spot next to that tree. Irony abound. Vieira, it turns out, had extended a lifeline to Shelton, offering employment when opportunities were scarce, aiming to change his stars. Yet this act of kindness met a most ungrateful ending. The unnamed colleague, sharing a truck-based abode with Shelton on the property, wisely dialed emergency services post-shooting and faced no charges. First responders unearthed the fresh grave, their body cameras capturing the futile revival attempts on Mr. Vieira, who had already succumbed to his injuries. Shelton, in a rare display of post-crime candor, offered apologies at the scene, musing to officers that, quote, it wasn't worth murdering over money, and acknowledging his impending lengthy incarceration. During sentencing, Vieira's bereaved family voiced their anguish, with his brothers lamenting the abolition of capital punishment in Colorado. The prosecutors highlighted Vieira's altruism, noting wryly that this was the thanks he received. Shelton's defense team, fulfilling their duty, portrayed the act as a momentary snap, though the family exited the courtroom during their remarks. Shelton himself remained silent. The presiding judge over there in Delta County, Judge Stephen Schultz, a man I've appeared in front of a couple times in my career, deemed the deed truly evil and unforgivable, mandating consecutive sentence to underscore his point. In this tale of betrayal buried in irony, one can't help ponder, if only patience had been part of the plot, perhaps the excavator might have stayed in the shed. You can't make this stuff up, ladies and gentlemen. A man helping out a young kid, hoping to get him a job, do him right, and this guy kills him and then buries him on his own property with his own equipment. That's cold. Cold. Next on the docket, this day in legal history. On August 18th, 1920, the Tennessee House of Representatives ratified the 19th Amendment by a narrow margin of 50 to 49, becoming the 36th state to do so, and thereby completing the ratification process. This amendment prohibits denying the right to vote based on sex, marking a pivotal victory in the women's suffrage movement after decades of advocacy and legal challenges. It's fundamentally expanded democratic participation and influenced subsequent gender equality jurisprudence. Think about it, ladies and gentlemen. One vote away, and women would not have had the right to vote. 50 to 49. One other vote wouldn't have happened. Now, it would have happened later, but not back in 1920. Then on August 18th, 1958, Lolita was published in the United States by G.P. Putnam's Sons. Although the novel faced prior obscenity challenges in Europe, its U.S. release prompted debate on First Amendment protections for literature. And while not immediately censored, it contributed to evolving legal standards on obscenity, as seen in later cases like Roth v. United States in 1957, which refined definitions of protected speech. On August 18, 1963, James Meredith became the first African American to graduate from the University of Mississippi, earning a degree in political science. Now, this event followed intense legal battles, including a 1962 Supreme Court order enforcing desegregation under Brown v. Board of Education. Meredith's enrollment and graduation symbolized progress in the civil rights enforcement amid federal intervention against state resistance. And on August 18, 2005, a Kansas judge sentenced Dennis Rader, known as the BTK, bind, torture, killer, to 10 consecutive life sentences, the maximum under state law, for murders that he committed between 1974 and 1991. This high-profile case involved complex legal proceedings, including Rader's guilty plea, and underscored issues in criminal justice, such as the application of sentencing guidelines and victim impact statements. And on August 18, 2014, Missouri Governor Jay Nixon deployed the National Guard to Ferguson amid protests following the police shooting of Michael Brown on August 9th. This action raised legal questions about First Amendment rights to assemble, excessive use of force, and militarizing police. These events spurred a federal investigation by the Department of Justice, resulting in reports on systemic racial bias in law enforcement and reforms under consent decrees. Next, our legal quote of the day has to do with revenge. Revenge is a kind of wild justice, which the more man's nature runs to, the more ought law to weed it out. Goes back to 1652. So revenge, it's all been done before, ladies and gentlemen. In a bizarre twist straight out of a medieval farce, a St. Petersburg resident clad in full jester regalia decided that silence was golden, enforced at dagger's point. Please meet Anthony Marzola. Guy's 51, allegedly grew irate over the hum of a landscaper's mower tending to a neighbor's yard, and rather than opting for earplugs or a polite chat, he repeatedly fetched a foot-long blade from his vehicle and advanced towards the worker, Bryan, who brandished the weapon and demanded an end to the racket. Hansen cleverly maneuvered his riding mower as a makeshift shield, keeping the costumed aggressor at bay until the police arrived. Now, a nearby onlooker corroborated the scene, which unfolded around mid-afternoon. Police noted that Marzola's attire, a complete fool's ensemble, bells and all, persisted through his apprehension, adding a layer of absurdity to the affair. Now, though motive for the midday motley remains unspoken in reports, one might speculate a connection to Marzola's proprietorship of the psychedelic Jester Smoke Emporium, recently relocated to the area. Facing charges of aggravated assault with a deadly weapon, he was detained at the local jail, where a judge imposed a $15,000 bond and barred any further interaction with Mr. Hansen. Truly an episode that proves that all japes end in laughter. Some land in lockup. I wonder if he's going to show up in his little jester outfit in court. Probably. All right, that's all we have for you today, ladies and gentlemen. Hope you enjoyed the show. We'll see you next time. And remember, the Constitution matters.